Judge Nickell, tell me a little bit about yourself, about your background, and why you decided to run for the Kentucky Supreme Court.
Well, I'm a native of Kentucky. I obtained my law degree from the University of Kentucky College of Law. I've practiced law for 35 years, and 22 years of that time I was a practicing trial attorney, prosecutor, public advocate, and college instructor. I've handled all types of clients and all types of legal issues during that time. Then 13 years ago, the voters here in the 1st District elected me to serve as one of their 2 judges on the Kentucky Court of Appeals. And during those 13 years, I've served as the chairperson of the Personnel Committee. I've also served on the Chief Justice's Judicial Compensation Commission. And also over that time I've sat either as an associate or presiding judge on over 2,800 opinions that were issued. And of those I authored over 965. And of those that I authored, only 21 were ever set aside in whole or part, basically 2%. And so I think that demonstrates to the voters that I really do follow the rule of law, that I believe in judicial independence and judicial restraint. I have a record to prove that.
So in recent years, the most talked about thing when it comes to the Kentucky Supreme Court is people saying that the court is legislating from the bench. A lot of the most substantial pieces of legislation that have passed in the last couple of years have ended up in front of the Kentucky Supreme Court. So tell me what you think about that sentiment, that there is legislating from the bench, and what your thoughts were on each of those pieces that came in front of the court and the final decisions on those.
Well, I would begin with saying that oftentimes one's perspective of whether a particular court has engaged in judicial activism or judicial restraint depends on whether your cause prevailed in front of the court. I think you have to look at the whole body of work that a court puts out. I don't think that's a very fair statement to make in regard to our Kentucky Supreme Court. You can pick out cases on every side of the political spectrum to make your case pro or con, whether you're practicing judicial activism or restraint. But on the whole, I think their work demonstrates that they do try to follow the rule of law and follow it wherever it leads. In particular, I would point out that just in the last year, the right to work ruling came out where they supported the right to work law that was passed. Probably one of the most important economic cases, particularly from the perspective of the Kentucky Chamber, in at least the past decade. So I think they try to get it right. And as with any human body, agency, you can argue whether they did or didn't. But knowing the individuals that serve there, I believe that they're trying to follow the law and apply it to the facts presented. People have to remember, too, that judges and justices can only take a case as it's presented to them by the attorneys. Who have to develop the record of evidence to be considered. We can't go beyond that or outside that. We don't take evidence on the appellate courts. We base our decisions on the record. And then we apply the law, and particularly we look to the arguments that are made before us. There are rare occasions that we can go outside of that, but for the most part we're limited to the arguments that the parties and their attorneys have made to the trial courts before it comes before us. The appellate courts are limited somewhat in that respect. And then too, I would say if you don't like an opinion that an appellate court reaches, don't blame the judge or the justices necessarily. They take the law as it's presented to them from the legislative bodies and the executive bodies, and we simply enforce the rules. And anyone can read the rules, so some of the cases I think you referred to were not struck by our Kentucky Supreme Court based on substantive matters. They were purely procedural matters where they sent the legislation back for proper procedures to be followed. Some people may question, why is that important? Well, procedural rules were set in place as protections for every citizen. It's to ensure that our legislative and executive branches follow well-known published rules in presenting legislation, sometimes presenting legislation to the public for a vote in the instance of a constitutional law change. And it's not... I don't know that it's always fair to blame the judge or the justices or the court, and certainly I'm sure in some cases there's plenty of blame to go around. But anyway, my experience on the Kentucky Court of Appeals and my working relationship with those who have ascended from that court to the Supreme Court would be that each individual has, even those I've disagreed with and dissented from on occasion, they honestly tried to follow the law based on the facts to wherever it led. And I would also remind the voters too that sometimes a judge or a justice is called upon to write an opinion with which they disagree. If they're a good judge, I think it was Justice Scalia, and before him Justice Jackson, who said, and others have said it as well, basically that you're not much of a judge or a justice if you haven't on occasion written some opinions that you personally disagree with.
So here in Kentucky, we elect our justices. In other states, and it's in a nonpartisan fashion here in Kentucky. Other states, they run and it's a partisan race. Other states, they're appointed. So how do you feel about the way that we decide who is on the Supreme Court here in Kentucky? And how do you feel that these races can be elevated so that it has more public attention and more voters feel informed about their decisions?
Well, based on what I've just said, I would say how I feel doesn't really matter, because I have the Kentucky State Constitution to guide me. And until it's changed by those who have the power to change it, our legislators, executives, and then ultimately the people, that's what I have to follow. And our Kentucky State Constitution mandates that judicial elections be nonpartisan. And I think the reason why our Commonwealth's founders wanted it that way was they understood the need for judicial independence. That is, a judiciary, judges and justices who are not controlled or guided by any party or partisan influence or special interest influence, but who will be guided solely by the law in regard to the facts of each case. And that's the beauty, I think, not only of our Kentucky Constitution, but our federal Constitution. We had founders who were wise beyond their years. And I think we make a mistake when we start to tinker with the wonderful system of checks and balances that they set in place. I'm sure we could all point to certain situations where we were displeased with some action that a court may have taken, or the legislature may have taken, or the executive branch may have taken. But we have checks and balances within our system which will address those concerns. But to wholesale try to take the independence of any of those three branches away, I think is a mistake. And I fear what this nation, what this Commonwealth would soon look like if we ever allowed that to happen. We have examples of what it would look like all over this globe. And I'm proud to be an American. I'm proud of our Constitution, both federal and state, and I think we need to fight to preserve them.
So, like you said, there are multiple different branches of government, each very important. But what do you feel is the most important role of the Supreme Court?
Well, ultimately, the Supreme Court is the last arbiter, decision maker of what the law is and how it should be interpreted and applied. That goes back to the founding of our nation. And so that would be its primary role, to see that justice is done and that all people, all groups have access to justice, have access to the courts. We have a jury system here in America that is a standard that other nations look to, that we need to protect and preserve. Your right to your day in court and to know that you will be fairly heard and that a decision will be based on the law and nothing else. Everyone has that right. And I like to say that when someone comes before, whether it's the Kentucky Supreme Court, the Court of Appeals, or any trial court here in Kentucky, that when they enter that courtroom, they should find that the ground is level before the court, and that they will have a fair hearing and ultimately a fair decision.
Now, as a judge, you've made a lot of decisions and written a lot of opinions. So can you point to a couple that kind of you think best define your judicial philosophy?
Well, I'm rather proud of every one of them because I take the same judicial philosophy forward when addressing the most complex case, one involving a number of legal issues, and what some would call the more routine appellate cases where there's only a single issue involved. And that approach is to follow the law and to apply the law honestly to the facts and to reach a decision that is reasonable. I look to the reasonable interpretation of the law as it was written and try not to read into it any modern concepts or perspectives. Quite frankly, I trust the legislature and the executive branch to deal with that, and if law needs changing, to let them do that. So I don't know that I can identify any one in particular opinion that I've written or been involved with. They're all important in their area, and the smallest ripple that the most routine opinion may cause can have huge consequences down the road. So you have to be very careful about not only the decision you write, but how you write it, the words you use. Words have meaning. As a jurist, I look to the meaning of words, to their plain meaning, and to what the intent was of the framer. And so, in the same way, my office, my staff and I, we pay great attention to wordsmithing, if you will, to make sure, or try to make sure that the most succinct word is used, understandable language that everyone can understand in applying the law to their everyday businesses. The law allows businesses and individuals to base their conduct on or predict the results of their conduct. And so it needs to be clear, succinct, and something that the general populace can understand and apply.
So I want to ask you before we wrap up and go to your final comments, Of all the U.S. Supreme Court justices, past and present, who do you admire the most and why?
That is a difficult question to answer because we've had so many wonderful justices over the course of our American history, and I could make a case for each and every one of them, and might be able to make a case against a few of them. But I would certainly start out with the early justices who helped establish the role of the judiciary in this nation. But I think playing it forward a little bit, I would certainly point to Justice Jackson, and then after him, Justice Scalia. I think if any modern day justice reflects my philosophy, or if I reflect theirs, it would certainly be Justice Antonin Scalia, who I have the highest respect for. I think he embodied my approach to making a decision, and many of the things I've said today and that you'll hear me say in speaking to groups around our community really came from him and his influence on me. He had a huge influence on a whole generation of lawyers and jurists, and so I would lift him up as probably my role model, if you will, but couching that or conditioning that on saying as well that many of them had an influence on me, and all of them had a hand in writing and interpreting and applying our Constitution. So I would say Scalia, and he's one who said that a good judge may have to write an opinion they don't agree with, but if they're an honest judge, if they're a fair judge, if they're a good judge, they will interpret the law as it was written, as it was reasonably intended by the framers, and apply that to the facts as were presented and proven in the trial courts. I try to embody that, and I think my record proves that I have done that. I'm not sitting here just giving you rhetoric because I'm running for office. I'm sitting here as a judge, a jurist, who has a 13-year record of doing exactly what I tell you that I'll do when I rise to serve on the Supreme Court.
So finally, is there anything we haven't covered or anything that you want the voters to really understand about you or your intention to be on the Supreme Court before the election? A message to voters that you really want to convey?
Well, for me, the Kentucky Supreme Court is, at this stage in my life, my professional career, the final destination. It's the last natural place to take the skills that I've developed as both a practicing trial attorney and now a judge, an appellate judge, to take those skills from the Commonwealth's second highest court to its highest and put those to work for the people in the same way that I have in the past 13 years. I am, at this point in my life, who I am. People know me. Other groups, other individuals may try to redefine me. But if you want to know who I am, speak to the people who know me best. And those would be the professionals, the attorneys, the judges who I work with every day and who I've worked with every day for the past 35 years. They'll tell you who I am. They'll let you know that I'm conservative, a lifelong conservative, a person of faith, of family, who believes in the Constitution, all of it, who enjoys exercising my Second Amendment rights as a gun owner and sports person, and who believes in free market capitalism, but also understanding that individuals and groups have certain protections under our laws that need to be enforced. In aspiring to serve on the Kentucky Supreme Court, I approach it with the same intention, the same hope that I had, which led me to become a lawyer 35 years ago. And that was that, you know, as a young person, my heroes were ministers and attorneys. And I was torn between whether to pursue a career in the ministry or in the law, until as a very young person I realized that someone can have a ministry while practicing law. And so as a lawyer, as a jurist, I have tried to follow the greatest commandment, which boils down is simply to love God and to serve His people. And I try to do that honestly and in a fashion that is pleasing to the God I serve.